Cuba Observatory, and that's why I'm here instead of another familiar face. Cuba Observatory sponsors a variety of events related to Cuba, past and present. And for kind of the highlight of the year in my mind was to invite our speaker today, Adriana Chira, who will be giving a talk called The Price of Virginity, Enslaved Women's Properties Claims, Sexuality, and the Law in 19th Century Cuba. She comes to us from Emory's history department, but she's a specialist on Cuba, but not only Cuba. She's a social historian who has written about various points in the Hispanic world from the 17th century to the 20th century. So even though I think she's really a master of 19th century, it's amazing. It's like when you meet someone and they're like a marathon runner and you think they're great and they say, actually, I'm a triathlon athlete, right? I mean, her skills and her knowledge is so vast. So thank you, Professor Chira, for joining us today and sharing your work, which I understand is from not your present book project, but the one that's coming out after that. So this is really an advance notice of what's happening. And so now I'd like to ask Kimberly to come up and introduce our speaker.
Hello, everybody. Adriana Chira is the Winship Distinguished Research Professor of History and an Associate Professor of History at Emory University. She works on slavery, law, emancipation, and recently consent in Cuba and Latin America. She's the author of Patchwork Freedom, Slavery, Law, and Race Beyond Cuba's Plantations, which won the James Rawley Prize for Atlantic World History from the American Historical Association, the Peter Gonville Stein Prize for Best Book in Non-U.S. Legal History from the American Society for Legal History, the Outstanding First Book Prize from the Association for the Study of the Worldwide African Diaspora, and the Elsa Goveia Prize for Excellence in Caribbean History from the Association of Caribbean Historians. Let's go.
Thank you for being here. I know it's a complex time in the semester, in the quarter, right? I'm on a semester schedule. So thank you to Lisa. I've been in conversations with Lisa for probably a decade, since I was like a big grad student. And I was very anxious, I remember, when we first met. So it's very nice to be here. I'm very grateful. Thank you to Samantha. I'm very terrible with infrastructure and details and with emails. So, but Samantha put up with me. So this is, I'm going to talk about the project that's in progress, which of course, as many of you know, as you are writing papers to conclude the quarter, it's an exercise in vulnerability. Okay, so please bear with me. If things don't make sense, I'm very happy to discuss them, and please point them out. Okay, because they will help me improve the statement. The work is a collaborative project that this particular art that I am co-writing with Aysara Ferreira Diaz and Maria de los Ángeles Mourinho Fuentes, two Cuban historians who are based in Havana. Okay, so let me start with a lawsuit, with a court case. And I think you guys the students have read an article of mine that also starts with a lawsuit. So in 1804, Juana Josefa de la Torre, a young enslaved woman, appeared before a local court in Havana to accuse a free man named Nicolás Aguado of estupro. In Spanish law at the time, estupro referred to the crime of deflowering a virgin who was a minor being somebody who was under 25 years of age. That deflowering would have occurred through violence, deceit, or apparent consent. Aguado had promised Juana Josefa de la Torre a sum equivalent to her Freedom Prize, her manumission prize, in exchange for her virginity. But he deflowered her and he never paid. De la Torre likely knew that her chances were slim. It was her word against his, and she was enslaved. And indeed, she lost in the lower court. But, and moreover, after 7 years of appeal, so this woman appealed for 7 years, right? She took her case to the Court of Appeal. she abandoned the case. Here's the central puzzle here. Enslaved women in North America, the British Caribbean, or the French Caribbean had no legal avenue where they could file complaints such as this one. In those systems, sexual violence against enslaved women was not a crime. It was a feature of domination. No court would have received a suit like that of us. So why could she file this kind of suit in Cuba at all? And moreover, why did other enslaved women in Cuba do so across nearly 8 decades? So until emancipation, which happened in Cuba in 1880. The laws were passed in 1880, and the last enslaved people gained their freedom in 1886. So the paper that I'm going to present, I'm going to just show you briefly the cities that I'm going to mention in the paper. Havana is obviously the first one here that I just mentioned. The second city I'm going to mention is Santiago de Cuba, which is the second largest city on the island at the time. It's still the second largest city on the island to this day. I'm going to also mention Matanzas, which was the area of the island that was the largest sugar producing area of the island in the 1840s. And Puerto Príncipe, present-day Camagüey, was the seat of the appellate court, which is how that is mentioned here. The paper itself is driven by sources. So historians have this stick. One way in which you can write papers, I'm mentioning this for students, is you write a source-driven paper. And this is what this particular article is going to look like. You find a source that is somehow very intriguing, and then you just have to write about it. And that's how I felt about this particular source, right? That I could not find equivalent types of documents in other kinds of archives in other empires. Time. I couldn't find the historiography around similar sources, right? So I thought I had to highlight the distinctiveness of this particular source. So here's what the documents look like, what these particular kinds of lawsuits look like. We are looking at 28 deflowering lawsuits filed by enslaved women, and we compare them with 38 deflowering lawsuits filed by free women. Free women who were deflowered by men usually were promised marriage in return for that exchange, and they would sue the men if that promise of marriage was not fulfilled, right? So this is what the documents look like. Just to give you a sense, this is a lawsuit filed by a free woman of color against a man of color whom she accused of estupro, and that's the entrance to the archive, the Archivo Nacional de Cuba, right? Which some of you have visited. Let me just go back. Okay. So here is the central argument. I argue that enslaved women assert property rights in their sexual bodies, a legally precarious claim to redress the subtly criticized slavery. Unlike free women who could bring criminal charges for being deflowered, enslaved women were confined, however, to civil jurisdiction and could not frame their cases as sexual crimes. Within these constraints, they articulated their claims as property disputes, treating their sexual bodies as a resource that had been abused. Enslaved plaintiffs' deflowering lawsuits challenged the honor-centered paradigm structuring colonial Cuba's social hierarchies at the time. Honor, as some of you might know if you've read colonial Latin American historiography, was a key category to which social status had traditionally been allocated in colonial Latin America. In elite discourse, honor denoted social standing rooted in lineage and adherence to social norms. Honor derived from publicly negotiated legitimate birth, good family, education, occupation, public service, and conformity to prescribed sexual mores. Women's premarital virginity and marital sexual exclusivity were paramount, ensuring paternity and legitimate property transmission. Honor also functioned as capital. Some individuals would possess more honor only because others possessed less. Men controlled these contests by impugning the honor of women from rival families. and estupro played a critical role in this process. As historian Susan Sokolov has shown, in 18th century Buenos Aires, for instance, women were often raped by acquaintances, men seeking to tarnish competitor families' honor. So what wealthy lineages did to protect their women was seclude them, while poorer women were compelled to work outside the home and therefore faced more vulnerability. However, popular notions of honor could diverge and often did diverge from those held by elites. Among commoners, honra, which was a word used interchangeably with honor, carried fewer genealogical connotations, emphasizing behavior and personal merit. Long-term, stable unions outside of marriage could coexist with honra amongst commoner classes, amongst non-elite groups. Right? In their flowering suits in Cuba, enslaved women sought to decouple honor from social status and reframe it solely through the lens of property ownership. As they increasingly participated in market economies and monetized their labor in the 19th century, most of these women worked in urban settings, right, in marketplaces, or they sold part of their free time to families as domestic workers, for instance. So as they increasingly participated in market economies and monetized this labor, they began viewing their social position and relationships with superiors through the lens of property relations, i.e. fluid and negotiable, emerging out of their market participation rather than fixed by birth. They tracked promises and debts owed to them and claimed them, as we'll see in a second. The defendants, the men, and their counsel and the judges, in their turn, tried to block the plaintiffs' access to promised payments by denying them honor. So we see most of the women fail in their efforts. They insisted that only women with lineages had the right to file estupro cases, and by this traditional logic, estupro payments compensated lineages for lost virginity and possible marital unions, and enslaved women lacked such lineages, they argued. They could not claim compensation and had no legal standing in such cases, they argued. In some cases, however, as we'll see in a second, enslaved women did succeed in work, and they did so when they operated within the honor system's traditional terms and gained recognition as honorable through the patronage of elite members of local society. So if they could embed themselves in owners' lineages through their reproductive participation as mothers of owners' children, for instance, their freedom suits would prevail. Still, even when unsuccessful, their cases shaped expectations for compensating feminized labor within the community before and even immediately after emancipation. And I'm a very huge advocate for studying failed lawsuits, so lawsuits that don't necessarily succeed for the particular plaintiff who files them, right? But they might have lost the battle, but there might be a war out there that is still ongoing and that they might have contributed to winning in some way or another for others, not for themselves. So then here's the larger question. Why then did Cuba become a focal point for this kind of litigation, so for women litigating for payments for lost, enslaved women litigating for payments for manumission on account of lost virginity? And moreover, not just that Cuba was a focal point for such litigation, which I could not find references to in other Latin American societies or in British Empire context, imperial context, or French imperial context, but Cuba was also the site for jurisprudence around cases like this. So my colleagues and I propose one hypothesis. Throughout the 19th century, most freedom suits in Cuba centered on enslaved people's claims to property rights in their labor as they increasingly monetized it. They sued to recover money paid towards manumission that owner refused to acknowledge, for instance, or to enforce promises of freedom in exchange for services. Some enslaved women recognized Cuba's sexual economy, which depended on their reproductive and intimate labor, even though the island itself was not a self-reproducing slave society. Within this system, however, sex operated as a tool of domination through emotional and sexual violence. So what enslaved women did in these lawsuits, they responded by trying to define sexuality as labor. This strategy exposed them to racist tropes of Black women as morally deviant. Defense attorneys acting for the men routinely deployed these stereotypes, but the plaintiffs, already burdened by such stigmas, countered by portraying the men as predators and slavery itself as morally corrupting. In the words of Mireille Miller-Young, quote, "Deviance has a politics. It is a terrain of strategic labor," end quote. Black feminist theories such as Miller-Young have advocated for a reassessment of Black women's attempts to reappropriate sexualized representations of Black womanhood, and through that, some measure of bodily autonomy without losing sight of the violent constraints they face. So what we would argue is that we can see enslaved women plaintiffs' legal actions in 19th century Cuba through that lens, to wrest control from men by describing their bodies as their asset. Let me give you a brief historical context for this particular moment that the cases are turning in. As some or maybe many of you would know, Cuba underwent extraordinary economic transformation during the first half of the 19th century. By the late 1820s, it had become the world's largest sugar producer, a position that was sustained by steam technology, railroads, right? There were railroads in Cuba before there were railroads in Iberia, right? And those railroads were used to move sugar, not people, right? Also, this industrial sugar revolution was sustained most importantly by the mass importation of African captives through an illegal but largely unchecked transatlantic trade. The human cost was catastrophic, and the economic effects reshaped the entire island. Historians have focused primarily on Cuba's rural history and on sugar's expansion. We have far less historiography on urban transformations. I'm trying to piece together what was happening in Havana at the time and using secondary literature, and it's been actually quite difficult, surprising. But urban growth was dramatic. Havana's population increased roughly 4 times between 1817 and 1841. And these years, they're so precise because this is when there were population counts. Officials described a city in perpetual flux, crowded, expensive, and porous. A traveler writing in 1821 noted that even a small house would rent for between $8,000 and $14,000 per year, an exorbitant amount. The demolition of all of the old colonial walls that separate the old city from the new developments around it, a demolition that occurred in 1853, removed physical boundaries that had previously helped elites manage the proximity of rich and poor, white and Black. And this demolition triggered significant anxieties amongst the higher strata of society. Authorities responded with intensified surveillance, and much of the surveillance targeted women, and Black women in particular. Captain General Tapon reorganized daytime police in the 1830s and required people of color to carry lights at night, making nighttime mobility more expensive for them, even though people of color very often had to fulfill important tasks, labor-related tasks in the city, right? But they were burdened by these new requirements. In 1842, a city ordinance prohibited prostitution, giving elites a new tool to target the poor and poor women, right? A so-called zone of tolerance was established in 1853 to confine prostitutes away from elite neighborhoods, but these measures largely failed. It was very hard to separate people out within the city of Havana. People lived very close to each other. There was a lot of intimacy across color lines, and that intimacy, I'm not saying this to idealize it, rather to say that it came with coercions as well as this paper is highlighting. To understand what the this is the discussion about honor and freedom. Understand what enslaved women were doing in this work, we first need to understand what free women were doing and how how it differed, right? Colonial Cuban culture, like other colonial Latin American cultures, operated with the implicit understanding that sex functioned as exchange, one in which the female sexual body was treated as property. This transaction unfolded along a moral spectrum. At the sanctioned end was marriage, which and very few people got married, right? Most people, as we see, lived in informal relations, cohabited together. But at the sanctioned end was marriage, which provided women with dowries from their families and some payments from the groom's relatives in exchange for sexual capital, virginity, which guaranteed paternity and legitimate property transmission, right? So marriage went hand in hand with property transmission and property control amongst the wealthy lineages of society. At the morally ambiguous middle were informal relations of cohabitation, where unmarried women, where also we see cases of deflowering, estupro cases being filed, right? In situations in which unmarried women who cohabit with men were promised marriage and that promise was not fulfilled, they would file a lawsuit hoping that they would obtain that marriage. At the most prescribed end was direct compensation for sex, and this was prostitution, right? Compensation for intimacy. The purpose of estupro suits was not simply punitive. They were a mechanism by which poor women could convert the economic damage of lost virginity into social capital. It was a dowry substitute, a public clearing of their name, as we'll see in a second. And it was a means of recovering their marriage prospects actually within the community. How did these suits work? The plaintiff in a free woman's estupro case was typically her guardian, the father. Right? Although guardians were legally required to represent minor victims, their prominence in proceedings reinforced the idea that the purpose was to restore family honor. Right? Witnesses testified to the woman's good character and the defendant's promises of marriage. Pregnancy was often what forced the case into public view. Guardians frequently demanded alimony and the recognition of the unborn child alongside the dowry if marriage was not possible, right? And sometimes, they concede that marriage was not going to happen, right? But most of the time they ask for marriage first and then the alimony and the recognition of the child with dowry. 3 questions appeared consistently in every case, and judges answered yes to all of these 3 in the 38 cases that we reviewed. Could a woman who worked in public spaces claim honor? They said yes. Could a woman who had cohabited with a man for an extended period still claim honor? They said yes to these 2. And could a woman of color claim honor? And they said yes to this question as well. Of the 38 free women plaintiffs in our data set, 21 received some form of relief. So let me introduce you to 2 cases to give you a sense of how this worked in practice. The first case is that of Maria Josefa Hernandez from 1807. She was 15 when the lawsuit was filed. Was born in a poor family. They were poor, living on rented land just outside Havana. Her mother washed laundry for the accused, a 27-year-old itinerant egg seller from Tenerife. He was from the Canary Islands, who frequently stopped at their home on his way to and from the city. The father of this adolescent woman filed the case. His daughter, he said, had yielded to the man's advances because she was, quote, a weak woman, and, quote, who trusted his promises of marriage. She was now 5 months pregnant. The decisive evidence in this case came from a local woman who testified that the defendant had approached her seeking, quote, remedies to restart a woman's suspended menses and, quote, a thinly veiled request for abortifacients. This witness refused. She claimed once she realized the woman in question was more than 3 months along. Armed with this testimony, the family won the lawsuit. At the last moment, the defendant decided to sign a marriage contract he was released from detention, but then the next day he fled under the cover of night. So courts could only achieve so much, right? And we can talk later. I see some of your questions here. They are in front of me. How much do we focus on the law? What does the law do? And what can the law do and what it cannot do? What are the limits of the law and what are the limits of a historian's attention to the law, right? The second case study involving a free woman, this one involves a free woman of color. It is that of Francisca Rangel from Matanzas. It illustrates how free women of color successfully claimed honor and how their lawyers argued for racial equality within the honor framework. The case involved a 13-year-old girl assaulted in her home by a free man of color while her father was outside. One thing I really want to stress is that the free women of color only filed estupro cases against men of color. I have not found a single case that they filed against a white man, right? There were witnesses, neighbors who witnessed the girl flee the house screaming. Francisca's mother, so Rangel's mother, sought justice, she said. She didn't seek money. She correctly understood that the defendant had actually little to offer financially. He was a poor man. And she was more concerned with clearing her daughter's reputation. She actually wasn't even that interested in getting her daughter married to this man, right? At the appellate level, Rangel's lawyer made a landmark argument that deserves to be quoted at length. Although those who care about Cuba's criminal statistics do not pay attention to the honor of a poor Black woman, given the immense distance that criminal legislation places between the two races, for men of heart, and above all, for those devoted to justice, which ought to be equally benevolent and protective toward all, these continual attacks on modesty in the countryside should not go unnoticed. If for the other classes, the honor that has been taken from the Black women they represent is irrelevant, it has nevertheless been the greatest loss she could suffer, for it has left her incapable of pursuing the only future available to poor women, to find a husband who might support her, since she can no longer offer the only dowry the poor can give, which to his mind was this woman's virginity. The appellate court sentenced the defendant to 2 years in prison and ordered him to pay a 200 peso dowry, only to discover that he was already in prison for another crime. And the plaintiff did not receive the 200 peso dowry because the man did not have that money, and she likely bore the court costs herself, right? However, it seems that she received at least part of the redress that she had pursued, which was a clearing of her reputation. The mother didn't want the community to believe that the young woman had enticed this man in the house, right? She wanted to describe this as an estupro, as a rape. Here is one of the important points I want us to leave this particular section with. Free women, whether white or of African descent, use the flowering cases to defend their standing within the community as honor understood through the traditional framework. They were claiming inclusion in the honor system, not trying to replace it. That project of replacing the honor system was left to enslaved women. And I want us to now turn our attention to those cases. Enslaved women occupied a fundamentally different legal position. They were excluded from criminal jurisdiction for this case, right? So they could not accuse the man of committing a sexual crime. Sexual violence against them was not a crime in Cuban law. Their only avenue was the civil courts, and they framed their claims as property disputes within this jurisdiction. These constraints, however, forced an extraordinary legal creativity, both from the women and from their legal counsel, right? I don't want to say that the women themselves were the only force here, right? The legal counsel mediates that relationship between the women and the legal system, and they played an important role. The enabling provision for this legal creativity came from Las Siete Partidas, the medieval Castilian legal code that remained foundational in colonial Spanish law into the 19th century. One provision stated that owners who placed enslaved women in brothels for profit would lose those women to freedom. Enforcement of this provision in the Americas was essentially non-existent. But in the 19th century, as enslaved women began litigating for freedom on these two programs, right, some lawyers advanced a creative gloss of this measure. If an owner who prostituted enslaved women lost them, then by analogy, men who exploited enslaved women's sexuality under false promises owed analogous compensation. But please note that some enslaved women filed estupro lawsuits against men other than their owners. And I'm going to come back to this one because I think it's very interesting from a legal history perspective. That was the case of Juan Josefa de la Torre, with whom this presentation opened. Another enabling condition for this legal creativity was the possibility for self-purchase that existed for some, that some enslaved people could avail themselves of. Throughout the 19th century, the primary avenue for freedom in Cuba was self-purchase in installment through the process known as coartación, through which enslaved people accumulated money to work their own manumission and paid for that manumission gradually. At first, this was a custom that was gradually formalized into law, into written legislation. By the late 18th century, enslaved individuals would set a price of their freedom by offering a down payment. So they fixed their freedom price rather than having it change based on market forces across their lifetime, right? They could fix it by giving a down payment. They could request additional appraisals if they disagreed with the owner about their price. They were exempt from manumission taxes. And by the 1860s, they were entitled to wages proportional to the fraction of freedom they had already purchased. So if they worked in the urban economy on their own account during their free time, they could retain a proportion of those wages that aligned with how much of their freedom they had paid. This system made enslaved people in Cuba extraordinarily attentive to the market value of their labor and to the monetary worth of their bodies. This is why most freedom suits in Cuban archives are about these promises about the price of freedom, about property that enslaved people claimed, about debts owed to enslaved people, and so on. We could see then the estupro suits as an extension of the sensibility. If sexual access had been exchanged for a promise of freedom, that promise was a debt that could be enforced in court, the women claimed. Another enabling condition for this legal creativity was the doctrine of minoría, which allowed vulnerable subjects within the Spanish Empire to claim expedited free legal representation. Originally, this was limited to children, but the doctrine had been extended by the late 18th century to indigenous people, to the poor, and to the enslaved. This meant that enslaved plaintiffs had access to pro bono legal counsel and a procedural standing they could otherwise not have. So, working within these constraints and given these enabling conditions, enslaved women and their lawyers advanced a striking argument. Where free women sought compensation as a dowry, as repair to a lineage, enslaved women could not invoke marriage because they could not have been heard, and they knew that. So the lawyers claimed that they had no lineages, right? So their lawyers argued that freedom itself was the equivalent of marriage, and that manumission was the most analogous compensation to a dowry for the flowering. By this logic, then sexuality was property, and the promise to compensate it was a debt. The non-fulfillment of this promise was grounds for a civil suit. Let's see how this worked in some concrete cases. The earliest clear articulation of this argument appears in an 1801 case filed on behalf of an enslaved adolescent named Felicita in Puerto Principe. Her former owner, Fulgencio Betancourt, had promised her freedom in exchange for her virginity. She acquiesced, and the relationship continued for 2 years. Felicita's mother was free. She was a free woman of color, and she really didn't like this situation. So she petitioned for a change of owner with a local judge. And you could do that in Cuba. You had the right to petition for a change of owner in situations such as a sexual abuse, for instance, or physical abuse. And so she petitioned for a change of owner and then pursued legal action against the court. Mother and counsel employed honor-based language freely to describe Felicita. They argued that Felicita's freedom is the real and most analogous compensation for her deflowering, and quote. And the local judge granted her freedom. So her new owner received money from the former owner, from Betancourt, who had deflowered the Felicita. And that meant that Felicita could walk away free with her mother. Juana Josefa de la Torre's case from 1804 illustrates the defense strategy that consistently defeated these suits, right? De la Torre's adversaries' counsel attacked on two fronts. First, he impugned her character, labeling her as, quote, a prostituta who roamed the streets at night, end quote. Second, they challenged her legal standing on principle. An enslaved woman without lineage could not allegedly lose honor in a way a free woman could, he said. Compensating her for sex would amount to state-sanctioned payment for prostitution, he said. Worse, he argued, it would encourage similar suits, undermining public morality and social order. As I mentioned earlier, De La Torre lost in the lower court, appealed, and then dropped the appeal after 7 years. The most significant case, and the last one I'm going to mention here, in terms of legal history, involved Soledad Abad, a woman by the name of Soledad Abad, who sued Apolinario Abad, one of her deceased owner's sons, after he fathered 2 children with her when she was still a minor. He had promised freedom repeatedly in exchange for her virginity, and he had never fulfilled the promise, obviously. Soledad Abad won at first instance in Santiago de Cuba. They lived in Santiago de Cuba. So she won in the first instance district court. But the appellate court reversed the decision. The lawyer representing Apolinario Abad subsequently published a pamphlet denouncing the use of estupro as grounds for freedom. So I was telling you that there's jurisprudence around these cases. This is that pamphlet, and this pamphlet shapes basically how the courts are approaching these cases, starting with 1833, right, when this pamphlet is published. What is interesting is that Jose Serapio Mojarieta used the same language in the pamphlet that he had used in the court in the case. So I could compare the case files with the pamphlet itself, and it's the same language. He would transfer the language right to the pamphlet. So here's a little extract from the pamphlet. He says, frequently, slave women bring their owners into courts asking for their freedom papers in return for having granted them carnal access and following promises of freedom that owners had made to their slaves to be able to enjoy their bodies. But who would not deem such a claim scandalous and illegitimate? Precisely because freedom is so desirable, it should not be granted to those who engage in prostitution. End quote. Mojarieta refused to acknowledge that enslaved women occupied positions of profound vulnerability, right? He regarded them as the responsible parties. He argued that freedom and concubinage had to be disentangled, otherwise enslaved women would gain excessive leverage over their owners, he said. The impact was significant of this pamphlet. After this case, after Soledad Abad's case and the publication of the pamphlet 3 years later, in 1833, pro bono legal representatives became remarkably more reluctant to take up these suits. So the pro bono legal representatives acting for enslaved people had the discretionary power to decide which cases they pick up and which they don't. They have an enormous amount of power, right, actually over this thing. And many of them decide that they no longer want to take up cases like this. What we see is that the number of cases filed drops sharply after 1840. Of the 28 cases in the data set, 18 were filed before 1840. One lawyer representing a subsequent plaintiff explained that he accepted such cases only under exceptional circumstances, since doing so would, quote, introduce into society disorder and immorality and cause displeasure and quarrels within families, end quote. Which suggests how pervasive these situations were as well, I would argue. 11 of the 20, I'm not a big fan of using counting games and counting losses, how many are successful, how many are not successful. We can talk about that and the problems with doing that later. But sometimes it's good to see, okay, how often do people succeed and fail? Just as a piece of information, and I would not say that it's a final argument by any stretch of the imagination. 11 of the 28 enslaved plaintiff suits did succeed, that the women did succeed, either because the men or their surviving relatives chose to settle to avoid scandal, or because judges actually did rule in favor of the women following the death of an intestate owner. So if the owner died without leaving a will, sometimes the judge ruled in favor of the woman, right? And the woman basically sued the family of the owner, not the owner himself. Was deceased by that point. Judges ruled in women's favor under specific constellation of circumstances. A deceased owner with no outstanding debts, no heirs contesting the estate. There were heirs, but they were not asking for a piece of the estate, right? Patron witnesses willing to testify, and a woman who had successfully embedded herself in the man's social network. Right, so she could bring patrons to her side testifying for her, and some of these patrons were the deceased owner's friends or collaborators, or business collaborators sometimes. In these cases, the suits were less adversarial, deflowering claims, than probate cases, settling the accounts of deceased, right? In these winning cases, it's important to note the women emphasized their domestic labor, their care for the owner's children, and their treatment as a de facto spouse. By foregrounding this domestic service rather than sexuality, they made their claims more legible and less susceptible to the prosecution accusation. Right? There was a case of a woman by the name of Camila Beris from Santiago from 1834, where 3 neighboring coffee planters testified that the deceased owner had treated her, quote, as if she were his wife, end quote. And two pieces of evidence that he gave was that she had a key to every room on the estate, and that she sat at the dinner table with him. Okay. Success also was originally concentrated. It was more likely in Santiago than in Havana. This was the second largest city on the island. It had not experienced the full force of the industrial sugar complex. Very importantly, it maintained a demographically significant free Black population that owned both urban and rural property. And this population frequently supported still enslaved kin in legal proceedings, right? Moreover, enslaved people in Santiago were notably more litigious overall, and I can talk about this more later. They were more likely to pursue self-purchase and more attentive to the monetary value of their labor. Another thing to note that I think is important, 7 of the 28 cases remained unfinished. That's a very significant proportion. And my colleague Bianca Premo at Florida International University has pointed out that about 30% of lawsuits filed by subaltern individuals in colonial Peru in the 18th century were unfinished. Right, and that leads us to the question: why did that happen? Was it because the plaintiffs themselves were, they decided to drop them because they didn't have enough resources, because they were overwhelmed by the machine of the judicial system? And one of the conclusions she reaches is that perhaps they were using actually the court to reach a settlement within the community. So they were using the space, the public space of the courts, to shame the people they were suing, or to pressure them in this public manner, right? But the conflict resolution actually truly took place within the community, right? So the community in a way co-opted the machine of the colonial state into its workings, right? That's what these subaltern litigants will do. Okay, now, very good. We're wrapping up almost. So the sensibility that animated these suits, the insistence that feminized labor had economic value that must be recognized, didn't appear with emancipation. So I point out that the laws of emancipation were passed in 1880. They were gradual laws of emancipation, and the last people to become free were freed in 1886. Right. So a case from Santiago from 1883 illustrates the persistence of this logic and its continuing defeat. Right. Manuela Casamayor had obtained her freedom through self-purchase before general emancipation, 2 years before, actually, in 1878. Around that time, she moved into the home of a man named Luciano Paisan and undertook the domestic work of the household. In 1883, however, so 5 years later, she appeared before the small plains court in El Caney, which was the village next to Santiago that they were living in, to demand 200 pesos in back wages, roughly the equivalent of 4 years and 2 months of a housekeeper's salary in that region. So she separated from the man, and she wanted him to pay for all the household labor that she had done during their time together. Paisan's defense was simple. He said, well, she acted as his woman, como mi mujer. Cohabitation in his account was a familial relationship, not an employment one. Several men in his social circle testified in support. The judge agreed, and the woman lost. The parallel to the earlier stupro cases is exact. The argument used against enslaved women that their sexual relationship with a man disqualified them from economic compensation was now being used against a free woman. Emancipation had basically relocated the conversations about exploitation from owners to male partners. The legal logic that made feminized labor invisible remained intact, however. Okay, so what do these cases tell us by way of conclusion? This is Manuela Casamayor's lawsuit. This is what it looks like. It's very faint. The photo is not great. And that's an image of El Caney, of the village of El Caney, that was taken at the end of the 19th century when the US military was in Santiago de Cuba, right? And they took quite a few photos of the rural areas of Santiago. If you're interested, they're available on the Library of Congress website. You can use them for teaching or for presentations. They're great. Okay, let's see. Let's get in here. So what do these cases cover? First, the argument that enslaved women advanced that they held property rights in their own bodies and sexuality did not derive from abolitionist intellectual discourse, right? It emerged from lived experience and from the self-purchase system. Scholars of US labor like Andrew Stanley have shown how US abolitionists used the figure of the violated Black woman symbolically as an emblem of slavery's worst violence. But those same abolitionists imagined that in the post-emancipation world, freed husbands would have power over their wives' sexuality. The Cuban enslaved women were more radical. They claimed a right against any man, including men who were not their owners, right? And they did that themselves. They didn't have abolitionists speak for them. They went themselves into court to speak for themselves. The second point, historian Broadie Fisher, she uses the concept of relational power derived from and structured by personal relationships. Broadie works on Rio de Janeiro, on 20th century Rio de Janeiro. She's now writing a book on Recife, history of Recife in Brazil. So she uses the concept of relational power derived from and structured by personal relationships, as power that is essential to a concept that is essential to understanding how, I'm using this concept as essential to understand how the suits work, right? Success requires social networks, pattern witnesses, supporting neighbors, allies within the household. The law itself didn't work for the women by itself. the women were not asserting individual rights in a liberal vacuum. They were embedded in a patronage structure that was simultaneously an instrument of their subordination and a ladder to some degree out of it. Their claims were relational, not purely individualistic. The third point is that deviance is politics, right? The plaintiffs faced a consistent accusation that they were morally deviant, unworthy of honor. Defense attorneys deployed the stereotypes systematically. But the plaintiffs, already burdened by the stigma, turned it around. They described the men as predators. They described slavery itself as morally corrupting. And they suggested that the system, not they, was the source of moral disorder. They practiced the politics of deviance in Rainier Young's terms. Stigma is the terrain of strategic contest, not just the condition of victimhood. The fourth point is about the sort of expansion of legal personhood that women are trying to accomplish in this lawsuit and their legal representatives, in collaboration with their legal representatives. So when enslavement sued men other than their owners, they were claiming a public right, a right that didn't have anything to do with the relationship that they had with their owner, right? By asserting the right against an individual outside the enslaved relationship, they expanded the boundaries of their legal personhood. In cases where no owner mediated their access to the court, they demonstrated also a striking degree of legal autonomy. And they were not only claiming property, they were claiming subject. Okay, thank you.
Thank you, Professor Chira. We have, as you pointed out, some questions that our students have prepared. You're welcome if there's any of those questions that catches your eye to tackle them. And we also have questions from the audience. And I'm happy to moderate or
I can take them. You I'm here already. So how about I open and I can intersperse? I've already have my eye on some of the questions. If anyone wants to, and please introduce yourself so that I know what to do. So not just your name, just what to do a little bit. Yeah, please.
I'm Clara because I'm a postdoc here at class. I work on collective land rights in Brazil, specifically Quilombo's. And so I'm really grateful for your talk. It's really interesting to see like historiography used in this way and like issues that you do. And I'm wondering if you could give us a little sense of what's happening around the time that sort of, I'm thinking about it from the perspective of the state and the colonial state in Cuba at the time, like, and the sort of, like it's happening, some of these cases are happening after the Haitian Revolution, and there's this kind of fragility, or I guess the colonial state is under threat in some ways, right? When these slave revolts are kind of, uprisings are happening, and as you mentioned, self-regulation was very common. And so I'm wondering if you could give us a sense of, was this influencing at all this negotiation between enslaved people and the state, and how they were not, I wouldn't call it a concession, but in sort of entertaining these cases in the judge's perspective.
Right. So where is the political history? That's the question, right? And to what extent can you look at the law without considering it as part of these larger political processes, right? So on the one hand, I think the larger question, because what you pointed out was insurgencies, right? Insurgencies is the mechanism for obtaining access to rights, which is the story of the 19th century, right? The century of emancipation, age of revolution and age of emancipation. And then the question is, what is the place of the law in a century of social movements when we truly see the beginnings of like movement politics, right? 19th century. So first, you could see the law, and to some extent, that's what the colonial state is doing. You could see the law as a mechanism for releasing pressure, a pressure release valve, right? So, and that is precisely what we see the colonial government doing, particularly, and it's important to distinguish between different arms of the government, the monarchy versus the local power brokers, right? The captain general, right? And the captain general sometimes has, actually, the captain general has way more power on the ground in Cuba than the monarch, right? So when, for instance, the Haitian Revolution breaks out, the monarch passes a measure in 1789 that is supposed to protect enslaved people, right, from excessive violence from their owners. It's a measure that's passed not just in response, it's passed also in response to the opening of the slave trade. Yeah, that there's an opening to the slave trade, right? And he's like, monarch thinks, okay, they're opening the slave trade, there is unrest going on in the Caribbean. We need to make sure that the owners are not excessively violent because violence triggers insurgency. Now, this measure never makes it into the courts, right? And the owners themselves petition to cancel, to make sure that it's not being implemented, right? With the wars of independence, right? The interesting thing about the wars of independence, I never thought that I would find lawsuits happening during Cuba's wars of independence against them, right? So there are lawsuits that are being filed in, the war started, the 10 years war in 1868 and in 1878. There are lawsuits throughout all that entire decade of Santiago where the war really was happening, right? So people are reaching out to the state, even as they are contesting some people are, right? So you could see that, on one hand, you could see the different arms of the colonial government trying to control the pressure within the system by giving subaltern people access to the courts, right? You can see other branches of the government trying to prevent that. And then you can also think about enslaved people themselves trying to wrest control, right? And redefine the terms of the debate. And I think what is really important about you're pointing out, what I tried to do in my first book, and I was just talking to Lisa about this earlier on, and I highly recommend if any of you is interested in doing socio-legal history, I don't consider myself a legal historian, I think of myself as a socio-legal historian, do not think about the law outside of political economy, political history, right? The law moves because the street moves, right? We know that from the current context. The courts do not just, concede to the underdog, right? So for instance, in the case of Santiago de Cuba, the reason why it can work, the courts can, the enslaved people can make advances within the courts is because there is maroonage in the area, right? So whenever there's a spike in maroonage in the area, the judges are far more likely to decide in favor of enslaved litigants, right? So during the wars of independence, the same situation, right? Yeah.
Thank you, Professor Chira, for the presentation. My name is Olavo. I'm a fellow here. I'm doing my dissertation on early 19th century Brazil and liberalism. And the fortuitous, the timing is good because right now I'm writing a chapter of drug abolition and the struggle for drug abolition around the same time. And I was really interested when you're talking about the conditions in which the plaintiffs are successful in their cases, and it seemed from the conditions that the argument they could present, which was to remove themselves from the sphere of servitude and put themselves to the sphere of partnership or of life. And there's that quote that they had there, which seemed to be this. And I wanted to see if you could just expand on that, because then it's interesting to see the already after, where in that last slide that I had, where the person pursuing the remuneration loses because the argument was that they were already acting as wives. So I just wanted to see if you could expand on that.
Oh, why this woman lost and because right. So because the women who won, the enslaved women who won, the logic that in the end worked for them, that the logic that the courts would produce was the traditional logic, right? That it was if you inserted yourself into the lineage of the owner, right? The logic that the more radical logic of such as the one that was Juana Josefa de la Torre, for instance, before, she didn't try to pretend that she was her owner's partner,
Mhm.
she claimed compensation.
Mhm.
Right? That was not going to work. That was not going to find the court.
Mhm.
Right? So, and by the same token, so this Casa Mayor, the last woman I mentioned, she was also making a radical argument, wages for housework. Right, and the partner said, well, no, actually, she was part of my lineage in a way. Okay, so he won.
Yeah. Just found that the movement from one spear to the other fascinating.
Yeah. No, it's a very, very good point. It's the 19th century, right? It's when these spheres, like people are trying to define really hard a boundary between
Yeah.
as you know, right? It's like liberalism, and
Yeah.
it doesn't quite work, and everyone's trying to figure out what's in one, what's in the other. Yeah. Lisa.
Yeah, so thanks for this, first of all, and I have two small questions. One is, I think you said that no free women of color sued white men.
Right.
And then one thing that's sort of taken my attention for years is the racial identity of Canary Islanders
Oh, yeah.
in the Antilles, and
Yeah.
the fact that the man from Tenerife was not treated as white is something that I find fascinating, and I'm wondering, how is that reflected in the case? So that's question one, which should be quick. And then the other is, if you could talk about the way that honor works for the family of these free women of color, because there's a presumption of virginity, and that presumption of virginity comes in some ways from the family's honor. I mean, I understand these girls were very young at the moment of this school, but how did the family honor get narratively discursively created in these documents?
Right. So, so regarding the Canary Islanders, there was a term used for them that marked their whiteness as distinct, blanco de la tierra. Right. Right. And in this case, I don't remember the precise. I would have to go back to the notes on the case, right? To really tease out, and I should do that. Now regarding the families of color, and what's interesting is that it seems to me that the families of color, the women of color who protect their daughters, is usually the women who, it's much rarer for fathers to represent their daughters in these cases in which women of color file for stupro. And the mothers usually come forward, and they seem to be actually, it's interesting to find out, far less concerned about the family story and much more concerned about their behaviors in public, which is also part of honor. Right, so they emphasize, well, we stay at home at night, we do not go out in the street. My daughter was supposed to get married to this other man, or there's an emphasis on the behavioral nature, the merit-based qualities of honor, rather than on its inherited nature, right? Which is what you would expect amongst what historians have called commoners. I don't really like the term, but amongst people who are not wealthy, right? Yeah, it's about honor being the outcome of behavior rather than of birth status, right? Okay.
Hi, I'm Miguel Wolf, History Department. So your very first slide mentions the age of apparent consent at 25, which to me seems, given the laws today, and I would assume Cuba too, are more like teenage age, right? 17. So I'm wondering where did that age come from?
25?
Yeah, and what is apparent consent as opposed to consent?
Apparent consent, but it depends on testimony, right? And who is there to testify for you and their status in the community, right? Your behavior. There is a lot of hermeneutics that goes on in the sort of these cases, right? And 25, it's all over the legislation. 25, yeah.
Why that age?
I don't know why, but one thing I can tell you though is that it it gets lower and lower across Latin America. Right, so 25 is actually quite high.
I was just gonna say, 25 is the age where one could get married without parental consent.
Parental consent, exactly, yeah.
Yeah.
Right, so it's tied to that, right? Yeah. But it's an interesting point, that it's quite high,
Yeah.
right? So in Argentina, I don't remember exactly what it was in Argentina, but they kept lowering it throughout the 19th century.
In Argentina, it was 23 until the 1950s.
1950s really, okay,
It was still
Okay.
23.
okay. I'm wrong, yeah.
It'd be interesting to know at what point that age goes down.
Yeah, and what was the legal reasoning behind lowering it, right? And how tied it was to ability to get married, right? Consent as the right to get married rather than other kinds of rights, right?
There might be an interesting history here about the history of guardianship. In what is enlightenment, in middle class, we have this formulation that enlightenment is man's overcoming of his own condition of being a child, right?
Right.
Self-imposed, but the term used is guardianship. So you know, he's of course thinking of males who choose to be under the tutelage of others. That is the metaphor, but those who are under the tutelage of others are infants and women.
Right, right.
Yeah,
Exactly.
so there's
Yeah.
something there for sure. I mean, this enlightenment arriving behind.
Yeah. Should I don't know how much time we have.
We have 20 minutes. So
20
3
minutes, okay, so
o'clock, yeah.
let me take a question from here. while-
Just wondering, kind of getting online.
So, I can take, for instance, a question from Diana Cisneros. Is Diana? Okay, so this is a great question. The question is this: your argument. So you read. What did you read from? You read affective death
Animation
article, and was it the affective debts or the freedom with for the bonds with local bonds? Okay, it's one of those two. Okay, that's fine. So the question is, it's an excellent legal history, right? It's a question that resonates methodologically across affective debts. Yeah, that's what it looked like to me. So, you said your argument relies a lot on cases that did make it to court. Do you worry or think that the ones that did not get there might tell a different story or change it? Right? And is that something you would want to explore more? Of course, right? So that this is highlighting, the historian's bias, right? That we are working with what is in the archives and what is in the legal archive. In this case, is whoever was successful at filing, getting right all the way to the court. And what was entailed in getting to the court? You needed to sometimes have geographic mobility. That meant you need to have resources. You need to get away from your owner, right? In Santiago, you need to get across valleys and mountains, right? You need to have money, right? You need somebody to take care of your children whilst you were away, or you might take the child with you, the children with you, right? So, and once you were in the city, you needed to have the confidence to go to a pro bono legal counselor and convince them, be persuasive enough that your case is worth picking up. Some of these legal counselors, I would like to point out, were themselves accused of sexually abusing women, FYI, right? By doing 5 cases like this, right? So that's another thing to remember. The question is important for many different reasons. At the bottom of it, I think, is a very existential question for a legal historian. So if you're interested in social history, if you're interested in the histories of people who don't have power, don't have the power, right, from the top, right, the subaltern histories, is it worth delving into a legal archive? Isn't the law is made by the powerful, right? Even if we look, even when we have this impression that we get access to voice from subalterns, isn't that perhaps a mystification? Isn't that perhaps a delusion, right? That the powerful have perhaps built into the system, right? And the sources themselves are very seductive, right? Because they are stories, they seem to be quite complete as a story, contain biographies of people, they are multivocal, right? They have narrative in them, which historians love. But here are some other reasons why I think these sources are interesting. Latin Americanist historians didn't used to study law, right? They thought that law was not something that Latin America had, right? It was a place of lawlessness. Violence was what worked, right? And so, by the token, then, slave society like Cuba, the largest sugar producer for the world markets, a place with an absolutely astronomical mortality rate. There shouldn't be any enslaved people reaching to the courts. And actually, we do find them inside the courts. Okay, so yes, there are many cases that, the story is going to be skewed towards the women who did bring the cases. I do think what I find really interesting here, and that's why one of the ways in which I'm trying to, unsuccessfully resolve this issue is by pointing out that many cases are unfinished and what that means. The other way in which these cases might be important, not just to the women themselves, because your question suggests that these cases might be significant for the women themselves only, and they are an elite stratum of the enslaved population. But I think that their stories inspired others, or they became exemplary in some way. People knew of this. I do think that there was some kind of knowledge circulating about these cases amongst communities. Right, and that the courts were the resort of last instance, that there were attempts to resolve conflicts within the community itself through public shaming at first. I think the court was the last resort, right? Yes.
Thank you for your presentation. I really enjoyed it. My question is if you see a sort of transition or tension between commodification and honor, because it seems that the two things are present, but somehow they are,
Right.
flashing somehow. The idea that I can buy my honor, or enslaved people themselves are buying or want monetary compensation for their labor. Like there's a deepening in the minds of the people of the time that things have a price, and as the title of your presentation also suggests, the price of virginity. But still, the idea of honor seems to portray that there's something that is priceless. That honor is not something that you can buy. So
you still need the social networks to get it, right? Like the money itself is not enough in and of itself, right?
Yeah, I think the idea of honor portrayed a little bit that.
Right.
I wanted to ask you about like this tension or connection between commodification and honor.
Yeah, and I do think the thing about one thing to remember about these cases is that for free women as well, when they were married, right? They experienced it as a process of property exchange as well, right? It's just that the difference between enslavement, the sexual exchange involved in a marriage amongst free people, and this sort of sexual exchange that involved enslavement, besides the fact that there was far more violence and lack of power in the former, in the latter, right, situation, is that the compensation that the free women involved in marriage received went to their lineage, right? And that's what, in a way, turned that commodification into honor, transmogrified it into honor. Right? Made it look like it was not commodification, right? And the judges were far less eager to see what the enslaved women were doing as that transmogrification. They wanted to see it as monetized, as a monetization of sex, right? Even though free women were doing it too, right? Marriage, through the marriage process. right? But yeah, I think you're right, that there's an attempt for some people, that perhaps to expand, the boundaries of subjecthood and to not just be an economic object, but an economic subject. Right? Yeah.
You want to take another question from
Yeah.
our MA students, maybe?
From here,
Yes,
yes,
and-
yeah, because you guys have a class, right? And I don't know if you have to write about, so I should help you write something.
Yes.
No, I know that. So, this is what we do. We help each other. Okay, so Mirka, huh? So can I read the question? I started, I didn't ask for your permission. I just went on. So I realized that I was reading, I should have asked for your permission. So here's the question. It's a very good question. As many enslaved people pursued their cases with a more sympathetic ecclesiastical courts, these courts and deferring courts, such as royal and military, view the rare corpus of estupro lawsuits any differently than other cases. On grounds, I imagine that you're asking this question on grounds that there's just more moral condemnation, perhaps from the church around, and more opprobrium around sex, right? And so the thing about it. So for those of you who don't know, the judicial system in colonial Latin America was very complex. There were different courts, different jurisdictions, right? It was a legally pluralistic system. And the church itself has its jurisdiction. And it had jurisdiction over questions involving the sacraments, matrimony, for instance, right? And enslaved people had the right to get married. So any question involving enslaved marriages that went, awry somewhere or another could be resolved before an ecclesiastical court. Ecclesiastical courts could also get involved in situations in which the owner of the enslaved person was a prelate, was a member of the church, right? So if it involved property of the church. The ecclesiastical courts tend to be far more friendlier towards subaltern litigants, enslaved people, right? So this is something that again Bianca Perlo has pointed out. There's also an extensive study of ecclesiastical courts in colonial Lima, if you're interested on this topic, by Michelle King. She's a fabulous socio-legal historian as well, just like Bianca Perlo. So the thing about the 19th century in Cuba is that these ecclesiastical courts disappear. They don't work anymore, right? And the women come before civil courts, secular civil courts, right? And the system becomes far more streamlined, and there are fewer openings. The question is important because it reminds me, I should emphasize, that the avenues for access get closed down, right? There's just fewer possibilities. As the sugar industry escalates, the legal system also becomes far more controlled, centralized, streamlined, and enslaved people have only very specific routes they can take, and they have to function within those limits. Yeah. Okay, Kimberly Arriaga. The experience of female litigants centers around the relationships with slave owners. How did the social contracts and community witnesses impact on manumission cases, advocate for enslaved women's rights during this time? Were there major differences between the male and female litigants? Okay, let me start with the second question because it's very important, right? Women were far more likely to sue for freedom on any grounds, full stop. Clearly on estupro suits, they were more likely. But they were more likely to sue on any grounds. And that's because that's because the court, I think they understood that the courts were far more likely to see them as vulnerable and to appeal to that, perhaps to that particular representation of public imagination. So community witnesses were essential in a world in which paper and titles, property were so absent. They are not the world we live in now, right? So your social relations were your capital, right? That's how that's one thing that we see in the record.
And we
Okay.
have a question in the
Yes.
back.
Hi.
My name's Ethan. I'm in the Iberian Latin American Cultures PhD program. We met briefly virtually in Isabella Fraga's Cuba class. She brought me.
Oh,
on the-
yeah.
Lovely to see you.
Is there anyone else from that class here?
I don't think so. not at
No,
the moment.
okay.
Some of us are still around.
Okay.
A lot of these questions have anticipated my questions as well, so thank you for everybody's collective help with that. I'm interested in the role of the legal counsel. You mentioned they're kind of like mediators. They're operating pro bono in many cases, but then in other cases, they're also the ones that are being sued. And so I guess I'm curious as to like what kind of power they have in the community, why they were the ones in charge of these cases, why they took on these cases. If they were like abolitionists in certain proponents or yeah, just anything more that you could tell us about the legal counsels that act as this mediator and how they constructed these cases.
Right, so that position was a position that members of the ayuntamiento, of the local council were assigned. So one member of the local council in every city was assigned this task, right? And they would hold this task for 2 years, right? And it was assigned on a rotating basis. This meant that that they weren't doing this out of a particular sensibility, right? It was more of the demand that was placed on them. The other thing were they abolitionists? No, they weren't. Like, let's not kid ourselves, right? Because some people really want to have to have this image of these councils as being anti-slavery. They did not necessarily see themselves as that. They did not act, they definitely prevented, I'm imagining, many cases from coming forward, right? And sometimes we see complaints of people who did manage to eventually get their case to mentioning an earlier legal counselor who had prevented them from accessing justice. Many of them were owners of people themselves. Right. So because they were members of the local council, these people were the wealthiest people around, right? So likely they, by the 1840s, however, like talking about abolitionists, so we see abolitionists in Cuba, and where are they, right? If we don't only, the main voices against slavery were definitely amongst the enslaved and free populations of color across the island, and especially in the east by the time of the War of Independence. But amongst the sort of the white, let's say, liberal class, which is what abolitionists tended to be in other parts in Europe, for instance, right, or in the US, or some abolitionists, not there were significant groups of Black abolitionists in the US. There are some individuals concentrated in the appellate court. There are lawyers working in the appellate court, bringing cases before the appellate court. So that argument for the honor of free women of color was put forward by a lawyer working for the appellate court in Puerto Príncipe. And those people were incredibly erudite, but also they put forward some very radical positions for the time of Cuba. Right, and I'm not sure exactly why they're, I understand they're there because the appellate court is there, but there's no study yet of that concentration of people and what they think, and it's partially, this has to do with the archive of that court, right? It's a little fragmented. Some of it ended up in Havana, some of it is still in Camagüey, and some of it is in Santiago, actually. So, yeah.
It's almost time. I adjourn with some announcements and gratitudes. But I can't help but make a comment and really thank you. There is such an elucidation in your work of a period in late slavery that is understudied, a period where that an enslaved person could actually make an appeal to court is unfathomable, and yet, as you show, actually happened. There's great interdisciplinarity here. You say you're not a legal historian, but I think you also are a legal historian and a social legal historian. It works very nicely together. I'm curious as to, we studied, I think, maybe in this room with Rebecca, and when we studied the Siete Partidas,
Yeah.
and how the Siete Partidas just continues throughout Spanish America until the fifties in different shapes or forms. So it's really beautiful and interesting to see. But also it would appear, I wonder if because of the emerging capitalism on the island, that some kind of jurisprudential thought is also occurring because these cases seem to be informing each other.
Right.
And that is not what one is supposed to do with us.
Yeah, that's no.
That, you know, it's more deductive. I mean, you're following the law and not case history. That's way too common law, way too Anglo. So I am super intrigued. But truly, thank you very much,
No,
Professor
thank you.
Chira. Let us
Oh.
thank you again. As to announcements, I have two on International Workers' Day, May 1st. We're going to have a one-day conference co-organized with our sister institutions here in the Bay Area. So it's multiple universities and grad students involved. It's going to be a whole day. You're all cordially invited during the time